My name is Megan Harbaugh. I am a member of Pi Sigma Alpha Honor Society, one of the sponsors for tonight's event. Tonight's presentation is also sponsored by ACS, Phi Delta Phi, and Montpurg. This presentation is being recorded by Missoula Community Access Television as part of a media assistance grant donated to my organization by MCAT. For more information, you can visit mcat.org. And now I get to do some introductions. So I have the pleasure tonight of introducing Anthony Johnstone. He is an associate professor at the University of Montana Law School. Johnstone received his BA from Yale University and his JD with honors from the University of Chicago Law School. Before joining the School of Law here, Johnstone served as a solicitor for the state of Montana, practiced litigation as an associate in New York, and clerked for the Honorable Sidney R. Thomas United States Court of Appeals for the Ninth Circuit. Professor Johnstone has testified before the United States Senate Judiciary Committee and the Montana Legislature, and spoken at academic, professional, and popular events across Montana and the United States. I can't think of anyone more qualified to introduce our keynote speaker tonight. With that, I will turn this little mic over to Professor Johnstone.
Thank you, Megan. In 2009, in June of 2009, the U.S. Supreme Court set a little-known technical federal case for rehearing and reconsideration of whether Congress or the states could restrict corporate campaign expenditures. I was a lawyer for the state in Helena at the time, and most of the big states' offices had slowed down for the summer. And it fell to Montana to defend the state's abilities to address the century-old problem of large amounts of corporate money coming into elections. In that case, which was named Citizens United and finally decided a second time in 2010 on much broader grounds, the Supreme Court optimistically heralded a new campaign finance system that pairs corporate independent expenditures with effective disclosure, where citizens can see whether elected officials are in the pocket of so-called moneyed interests. And it went on to say, the First Amendment protects political speech, and disclosure permits citizens and shareholders to react to the speech of the corporate entities in a proper way. This transparency enables the electorate to make informed decisions and give proper weight to different speakers and messages. As we now know, this was wishful thinking. At the federal level, a sclerotic Federal Election Commission and polarized Congress could do little to bring sunlight to the flood of money into American elections. And in Montana, after a short-lived stand against Citizens United in the Western Tradition Partnership case of 2012, the lonely office of the Commissioner of Political Practices, housed in a modest two-bedroom block away from the Capitol, appeared to be no match for the major national interests seeking to skirt our state laws. By the time the Supreme Court had thrown out Montana's century-old Corrupt Practices Act, the office was on its third commissioner in 3 years, with no commissioner confirmed after the first 5 commissioners had been confirmed by a combined vote of 239 to 6, to give you a sense for the change in tone in Helena just in the past few years. Just 19% of the complaints that were filed since the year 2000 in that office had been resolved before the relevant election. So 4 out of 5 complaints were still standing. The weakened office, without its own legal staff, was left to settle multi-million-dollar violations of campaign disclosure laws for just pennies on the dollar. Enter Jon Motl, a modest Minnesotan. I'm at least the second of those, but came to Montana for its rugged landscapes and made a career in a private practice in Helena. Appointed in 2013, he expected to serve less than 2 years before eventually falling in the line of failed confirmations. Commissioner Motl not only survived a bruising confirmation battle in the 2015 legislature, but with the help of several courageous legislators, helped marshal the Disclose Act and its innovative reforms oriented towards making politics more accessible and moneyed campaign organizations more accountable. At a time when Montana politics needed it most, Commissioner Motl really for the first time brought the legal fight in court to a growing list of campaign scofflaws and brought newfound transparency and, yes, trust to Montana's Republican form of government. Please join me in welcoming Jon Motl.
Forgot to turn off my cell phone. First act. I'm very pleased to be here. If I can get this on, I'll even be more pleased to be here. Okay. So I am Jon Motl. I'm not only pleased to be here, I'm pleased to be introduced by Professor Johnstone. And I certainly knew him as a solicitor. I respected his work then, and I respected his incredible ability to write ever since when he's become a professor, particularly on campaign finance issues. Now, I'm particularly grateful of this chance to speak, and I've actually put more time into this particular presentation than I have in other presentations. My tenure of office is due to end on 12/31/2016, and I thought this might be a good opportunity to offer some insights, practical insights, not the sort of First Amendment scholarly constitutional insights that were in Citizens United and all of the critiques that we've seen since. I think we got a smile on Professor Johnston on the scholarliness of Citizens United. But I want to start then by adding a little to what was said about my job. So my job is a full-time position in state government. I am a full-time employee of the state of Montana. I'm the Commissioner of Political Practices, which means I'm the head of the office of the Commissioner of Political Practices, which has 7 employees and a budget of about $550,000. It's either the first or the second smallest agency in the state of Montana. So start with that, and start with the fact that despite its small budget and its small number of employees, the office has attracted considerable attention. If we could have number 1 up, please. Even before I became commissioner, and you can see that the date on this is October 12th, 2013, and I was appointed commissioner on May 13th, that's October 12th, 2012. Even before I became in the office, the office was, commissioner's position was labeled top cop. And if we could go then to number 2, so you get to the position of political practices commissioner top cop by appointment. And so I was appointed commissioner by Governor Bullock. And then once you're appointed as commissioner, you serve for a period of time until the Montana legislature comes in. Now that's 2013, which meant I served from June 10th, 2013. I was in private practice, so it took a little while, and the great cooperation of my fellow attorneys in my office to accept cases from me. But it took until June 10th to transfer my practice to other attorneys so I could begin this position. So from June 10th, 2013 until January 1, 2015, I was commissioner by appointment, but you still have all the authority as commissioner during that time. Once the legislative session starts, then the legislature graciously considers your confirmation. If we could have the next slide. So the first thing that happens is you go to a Senate committee, and there I was soundly rejected. Well, I was voted out as commissioner, and not only was I voted out, but there was a procedural move. You table the vote, which makes it more difficult for the entire body to move to reconsider and decide whether or not they're going to approve you. But if we could go to the next page. There, okay, I was confirmed. And so I became a appointed and confirmed commissioner at the next to last vote of the Senate at the 2015 legislature. And I still am commissioner because once you have that, then you are confirmed. And I need to explain this because it deals with some of the insights that I'm about to offer you. If we could go to the next slide, 2, please. So the Missoulian, editorializing just before that vote in the Senate, said this is the most unpopular job in the state. And they noted that it's an important post, though, in charge of enforcing Montana's campaign and lobbying laws. And therein lies the reason why in the last decade, this particular post has become a post that has been subjected to considerable, I guess they said it was intense debate in the Senate, but it's for this reason. The Commissioner of Political Practices, once appointed, is not subject to control by any elected official, by any party, by any person in the state of Montana. Even though it is a 7-person office, the Commissioner of Political Practices functions as an independent entity. And the only obligation the commissioner has from the moment he's appointed, and even more so after he or she is confirmed by the Senate, is to the people of Montana. So it is a post that stands in that capacity and represents the people of Montana when it comes to campaign practices, and it does that regardless of political party and regardless of whatever elected official that a complaint may be filed against or that you're dealing with. And that is the reason why the post is unpopular and why you end up with the controversy getting the person in. Now, I was confirmed, and once I came into that job, the editorial, and I think Professor Johnstone said that at one point the office is called toothless. And that's largely because of the change in the workload of the office. If we could have the next slide. So if you could just go up a little higher, kind of center it so that you can see the whole thing. Okay. So here are, when a citizen has a concern about a particular campaign practice in the state of Montana, a citizen can file a complaint on that with the commissioner's office. The commissioner's staff is paid by the state of Montana, and they then look at that complaint and compare it to the statutory law, they compare it to the regulatory law, and then they issue a decision as to whether or not that particular activity conforms to the expected campaign practices in the state of Montana. These are the decisions for one commissioner, Commissioner Voy, during this time period. There's 44 of them during those entire 6 years. If we could go to the next list, please, and scroll the whole list. I've been there 3.5 years. Keep going. Keep going. Keep going. Keep going. Okay, 190 decisions in 3.5 years. Now, 60 of those were on the docket when I came in the door. They were on the docket all the way back to the 2010 campaign year. And there are now, on the docket right now, there are 2 pending complaints. And those will be resolved next week. We're current. We're keeping up with the ones as they're filed. But the significance of what I'm going to talk about tonight rests with the number of decisions that the office has issued in the last 3.5 years and it's with the breadth of those decisions. If we could go back to 13, let's see, get my notes here, I'll get the right one. Let's go back to 13.022. Yeah. Okay, right there. Okay, you see that one? I started issuing decisions at 1309. The 8 below were issued by the commissioner before me in the year 2013. That decision right there is Bonagoski v. Kennedy. It was the first of a series of decisions that were issued concerning a 2010 Republican primary election campaign practices involving candidates who had campaign involvement with a number of corporations. So I want you to remember that one, and I also want you to remember another one that I issued in that year. The next year, 1411 and 1426. Okay, right. 1411 is Bonagoski v. Boniak, because we're going to be talking about that as an example. And the next one up, 1426. That's Bonagoski v. Wittig. Both of those complaints came in. Deborah Bonagoski was a candidate in Billings, Montana, who ran against Kennedy in the Republican primary and was defeated by him by a blizzard of letters. She and her daughter sat at the kitchen table and managed to get 3 letters out on behalf of Deborah, doing it the traditional way, folding them, putting them in the envelope, mailing them. There were, in an average campaign in the 2010 election cycle, if you were on the Wittig side, the Boniak side, the Kennedy side, you averaged 24 letters, either on your behalf or attacking the other person against you. And we'll talk a little bit more about where they came from. But that was the difference in a primary election in just the direct mail campaign. And there were other components in it as well. But when the complaint comes in, the commissioner considers the complaint, and then there's a process by which the complaint is worked on. There's an investigator who looks at the facts, writes up the facts for the commissioner to look at. The commissioner writes a draft decision. The draft is circulated among 5 people, including an assistant attorney general, and then all of the staff people within the commissioner's office. The rules on, once it's circulated, is complete vetting. Anybody is free to challenge the logic of the decision and also complete editing. You can edit the words. But after that process is over, the commissioner gets all the stuff back, writes a final decision, and it's published. You can click on that decision right there. From any computer in the state of Montana, you can read it. When you can click on the complaint first, you can see the complaint, then you can click on the decision. When that decision is issued, it then goes to resolution. And resolution usually results in a settlement. You can click on that settlement and you can see that in Vote Yes Whitefish, there was a complaint, a decision finding a campaign practice violation. It was then settled, a fine was paid, the social debt was paid. You won't see that on Mr. Wittig. You won't see that on Mr. Prowse. The reason you don't see that on Mr. Wittig is because we were not able to settle it, and it went into litigation because you have 4 years to enforce a campaign practice violation. If you cannot resolve it by settlement of the party, you must go into district court. And we went into district court. We did that with 9 candidates in 2014. And it's those decisions primarily that I'm going to talk to you about the insights that I've gained about one particular issue. That particular issue isn't money in politics. It relates to money in politics. Instead, it's the juxtaposition of individualism in elections versus community in elections. How do those 2 concepts relate to one another, and how are they in elections? Let's start by defining first what I mean by that. So perhaps we can better follow what this means. Let's deal with community first. If you go to the next. Yeah, I think you go the other way, though, don't you? Oh, there it is. You are better than me. Okay. So what does it mean in community in elections in Montana? Well, community in elections in Montana, we are fortunate enough that it isn't something that I have to come up with. Shortly after Citizens United, Montanans put initiative number 166 on the ballot. Number 166 was approved on the November 2012 elections with a 73% voting margin. We owe C.B. Pearson in the audience a big thanks for getting that particular initiative on the ballot. Now, with that percent of voting, this is community standards in elections in the state of Montana. Professor Johnson would be the first one to say, and I would agree with him, that not all of these standards meet constitutional muster. That is, in a particular way, they may be checked by a particular decision on constitutional interest, but that doesn't mean that you don't look to this to set the general standards. And what are those standards? The standards are that people of Montana regard money as property, not speech, okay? That is that money doesn't necessarily translate into speech in elections. That's one of the community standards that we have in Montana. That the people of Montana regard the rights under the United States Constitution as the rights of human beings, not the rights of corporations. That is that in elections in the state of Montana, we're most concerned about the rights of human beings. Those are the people that should be participating in our elections. And that the people of Montana prefer a system that allows all individuals, regardless of wealth, to express their views to one another in their government. In a way, it's related to the money in politics. In a way, it's related to the corporate interest. But that is that word that specifically was stricken down by Citizens United, level playing field. To the extent that we can constitutionally apply that, then, that is the community standard that we use in the state of Montana. Now, how do you measure whether that occurs? Well, implicit in all of this, of course, is disclosure. It's reporting of what is involved in Montana's campaigns and looking at that to measuring it with the standards that remain after you remove the parts that aren't constitutional to see how it applies to the policy of the state of Montana. That is the community standard. Now, how do you compare that to individualism? We can go to the next slide. All right. This basically says, after the Disclose Act passed, that, the right to say anything to anyone without having to cite your name is pretty much the definition of free speech. And then it goes on to argue that philosophically, you should have no reporting and disclosure. That what you should have in elections is complete anonymity. If somebody wants to spend whatever amount of money, they can spend it. And you don't get to know who is spending it, because that's not free speech if it's reported and disclosed. This is not what I'm going to define as individualism tonight. This is a philosophy that can be tested constitutionally. That's what we have courts to do. They measure the extent to which you can require reporting and disclosure. But I do want you to understand that there is a philosophy, which I've heard repeated in the halls of the Capitol on more than one occasion. There's a philosophy that the community standard that I gave you, that 73% of Montanans voted for, is not this guy's community standard. He would disagree with every single part of it because he believes that election speech should be anonymous. But now let's go to where you get this sort of debate is a philosophical debate. It is a debate that plays out in the courtrooms. It's a debate that plays out in decision-making arenas. It is not a debate that I deal with on a practical level. Here is what I deal with on a practical level. And this is what I'm talking about with individualism. We go to the next slide. All right, remember I showed you the Boniak decision? We didn't settle it. We took it to court. Well, this is it's in the 1st Judicial District. There's the number of it. It was before a substituted judge out of Great Falls, Judge Pinsky. And the important thing about this decision is on page 2. This is individualism. Joel Boniak is not under the jurisdiction of the 1st District Court of Montana. There is individualism. This particular individual says flatly that because he is subject to laws to his creator and to people in general, he is not under the jurisdiction of those laws as organized in a community. He doesn't respect the jurisdiction of the 1st Judicial District. Now, before you say that that's a decision that we should just, or something that we should overlook and not pay any attention to, you need to understand that Joel Boniak was elected to the Montana legislature in 2008 from House District 61. He represented Park County, portions of Gallatin County, that area of the state of Montana that lies between Bozeman and Yellowstone Park, basically. And he was elected, served, and then in 2010 he ran again. And he ran again in a Republican primary election where he was opposed by another Republican by the name of John Asp. And John Asp is from a long-time family in that area. His grandfather served, his father served in public service, and John himself wanted to serve in public service. And he challenged Joel Boniak because he thought Mr. Boniak was extreme. The thing about those voting districts, and it's true for Democrats in some districts, and it's true for Republicans in other, this particular voting district is so heavily Republican that the only election is in that Republican primary. If you win that Republican primary, you are going to be a Montana legislator. The Democrat isn't going to beat you in the general. Now that's true for Democrats in this Missoula area, as you know. If you win the Democratic primary in Missoula, in many of your districts, you're going to be a legislator. You're not going to find a Republican beating you. So you have to look at the Republican primary. Now, we issued a decision on Mr. Boniak, and would you go to the next page, please? Actually, would you go to the next? You can keep going. That's an affidavit that Mr. Boniak signed. And just stop on the first page. Okay, findings of fact, conclusions of law. So, in order to take that community standard, which the Commissioner's Office believed was different than what Mr. Boniak had conducted himself in his election, we had to take that before a fact finder, and we did that. On June 10th, 2015, we held a hearing on the default judgment of Mr. Boniak. And what that basically means is Mr. Boniak did not agree with the jurisdiction of the court. He didn't appear. But that didn't mean the Commissioner's Office had any lesser burden of presenting evidence. We had to present evidence. And what did we present? If you go to page 3. Let's see, are we on page 3? 5? Yeah, we are, okay. Okay, at the June 2nd hearing, 2 witnesses were presented, Commissioner Motl and C.B. Pearson. Documentary evidence from an archive of Republican primary campaign documents assembled by the S family. The S family kept literally every document that was mailed against candidate Esp and put them in an archive, delivered them to the Commissioner's Office. Then we had documents delivered by Carolyn Rockvoy. She was a former employee of Western Tradition Partnership who quit and brought us in her document archive that she assembled when she left. And finally, we had documents delivered from Colorado to the Commissioner of Political Practices. That was our entire archive. That was our entire testimony. Now, go to page 5, please. And what that testimony in the document archive showed was that 2 corporations engaged in extensive, unreported, and undisclosed campaign activity supporting candidate Boniak or opposing candidate Esp. Among that were surveys, candidate letters, attack letters based on survey results, and attack flyers. And if you'd go to page 9. The finding found that WTP wrote, that's a corporation, Western Tradition Partnership, wrote the 8 candidate letters, that they assembled a targeted mailing list. The important thing is that they put together a mailing list. They printed the candidate letters, imprinted Joe Boniak's signature, folded and stuffed the letters into an envelope, addressed the envelope according to the correct mail list, and mailed those. Some letters required a first stamp, others didn't, but that evidence was presented. And if you go to page 21. The court found that Mr. Boniak had violated the campaign practice law by acceptance of illegal corporate contributions, found that amount of $21,120, and then doubled that for 2 violations. And if you go to page 22, the next page. Yeah, there we go. They found that this was corruption because he accepted at least $9,000 in corporate expenditures that became in-kind contributions to his campaign. So this was a violation of the community standard. And then just go to the last page, please. Signed by the Honorable Judge Pinsky, District Court Judge. Now, so the bottom line is you had an act of individualism by a candidate for public office in 2010, a rejection of any sort of review of his campaign practice, and then you had a court finding that he violated campaign practice law, and they imposed that penalty on him. But it still doesn't demonstrate, I think, the full range of individualism. It does, however, allow you to say, as a preliminary way, 2 things. There are those who, in an election process, do not accept or respect community standards. They don't accept or respect the standards set by the state of Montana, and they don't abide by them. Those individuals include Mr. Boniak in this instance, as the court found, and also the corporations that were dealing with Mr. Boniak. Now, the other thing that you can say about individualism in election actions based on this, and perhaps more stronger with the next example we're going to go through, is that because the act of individualism, and the act of individualism as it's actively applied in a campaign, is different than a philosophical discussion like we saw in that newspaper article. The act of individualism in a campaign means that you are doing something in your campaign. You're not reporting, you're not disclosing, you're taking money from corporate sources, you're using resources in a campaign that the other candidate isn't doing because they're complying by community standards. And what it means is that that act of individualism is going to occur. It is not going to be stopped by the publication of a community standard or a discussion of community standards, because the act of individualism implicitly rejects the community standard. In Mr. Boniak's situation, it was rejected by his refusal to acknowledge community to act together as an organized body, as a court, as a body setting campaign practices. It allows him then to function as Joel Boniak, individual, in a campaign in a way without regard to rules. If that is an act of individualism, if the act of individualism is going to occur, regardless of the community standards, the only way you can deal with that act is you have to react to it. You have to have some capacity to take the community standard, respond to the act of individualism, and apply the community standard on behalf of the community. And therein lies the conundrum of those cases that we had for waiting when I became commissioner. Those cases were the way in which the community could respond and had not responded. So let's go to example number 2. If we could go to the next. Okay, so this document is important for a particular reason. If we could go, well, you can see, could we go down just a little bit so we could see the date on it? Other direction, I think. Yeah, a little bit more right there. It's April 5th, 2010. And it has got a number of names on it. I'll tell you that those are candidates for public office in Montana. There's Mr. Boniak, he's listed on there. And there's Mr. Wittick, he's listed on there. And it invites them to a training session in Bozeman. And I'll tell you at that training session, there were 2 officials from the National Right to Work Corporation which offered training to the candidates. Now, when you saw what we had for Mr. Boniak in that June 2015 hearing, that's when the evidence was presented, even though the decision was made in June, we didn't have this. This particular document came later. It came later in the second case that we looked at in detail, and that was the case involving Mr. Art Wittick in Bozeman. Mr. Art Wittick, the litigation in that case started shortly after I was confirmed as commissioner in May of 2015. And we engaged 2 attorneys on a pro bono basis from private practice out of Billings, Gene Gerussi and John Heenan. And Mr. Gerussi had retired, come out of retirement, and worked full-time on the case for the next year. The Wittick trial was held in April of 2016. Because he worked full-time and because we had no money, he did his own investigation. He traveled to Seattle 3 times and finally found Andrew O'Neill. We knew from the Colorado documents that these folks were there. We just didn't know who they were. He found Andrew O'Neill and found out that Mr. O'Neill was employed by National Right to Work. Not by Western Tradition Partnership, National Right to Work, a Virginia corporation. Andrew O'Neill gave him Sarah Anderson's name. She was now Sarah Arnold living in Denver. He tracked her down in Denver. She also was hired by National Right to Work. We got approximately 60,000 documents, pages of documents, emails, documents used in the campaign. We didn't get a single document from the candidates when we put our demand for documents to them. We got them from these young 20s people who were working for a conglomeration in Livingston that was organized by National Right to Work. We found out by looking at the documents and by interviewing these 2 people that the principal person, Christian LaFerd, that we thought was the leader of Western Tradition Partnership, was really a field employee full-time of National Right to Work. That his wife, who ran the print shop that we're shortly going to look at, was also paid by National Right to Work. That Andrew was paid, Sarah was paid, Jeremy Hofer was paid, and a number of other people were paid. This was an organized group of people paid by a single corporate entity assembled for the purpose of providing services to candidate Mr. Boniak, to candidate Mr. Wittig, and that is the new knowledge that we had as we proceeded on this case. It was far more serious than we first had thought when we got into it with the documents. We also found out that Sarah Arnold was the source of those first 3 boxes of documents that gave us some insight into this case, the infamous Colorado documents. Sarah had taken them in a car from Livingston, was driving him to Colorado, had stopped off for a brief time at a campaign rally. Somebody broke into the car, stole the car, and those 3 documents then ended up in a house of ill repute in Colorado and were eventually sent to Colorado. But now we had a person who could identify the documents. So let's go on and go to the next phase. Let's go to number 12, the next one down. So here is what we originally thought we had with the 24 documents. We knew from the S Family Archive that in May 3rd through 10th, with the primary election being in early June, there were 6 candidate surveys that were sent out from these groups, right here. These were all corporate entities. At the same time, Mr. Boniak sent a Monday morning letter announcing he was running for the House District 61. Among the documents we received from those various email archives that we got from Sarah Arnold and from the other people was a email from Jed Coburn, a National Right to Work staff person in Washington, D.C., who wrote this particular document on behalf of Mr. Boniak, mailed it in a PDF and Word form to Mr. Boniak and Mr. LaFleur, who then reprinted the document and imprinted a scanned signature that was given to them in Livingston. Now, the same thing as you go through, all these things as you go down, would you just go down? 5 to 10 attack letters, 4 Boniak issue letters. These are particularly important. These issue letters are all built around issues: abortion, taxes, spending, and guns. There's the same 4 issues, they just differ according to legislative districts. National Right to Work surveyed into those districts, determined which of the voters in those districts were aligned on those issues, and then mailed those specific issue letters, which again Jed Coburn wrote, sent under an email heading into Montana, sent on behalf of Mr. Boniak, on behalf of Mr. Wittig too, when we get to him, and was sent to that issue ID'd list. And then the final letters and the attack pieces. The attack pieces was another National Right to Work person who drafted the glossy letters that were mailed out attacking the opposing candidate. So let's go to the next piece, please. And this is the direct mail, and the infamous words that they had here is they described their, if you could go down just a little bit more. Okay, their print shop they described as the printers were the infamous wall of Rissos, reminiscent of the Iraqi highway of death, and equally as destructive to those who would stray into the path of one of direct mail's shock and awe electoral bombing campaigns. They weren't kidding. 24 of them going out between May 3rd and June 10th in a Republican primary election against an opponent like Miss Bonagoski, who was sitting at a kitchen table with her daughter, fighting back against the Iraqi highway of death. Not a fair fight, not consistent with community standards. Let's go down to the next one. Okay, and how did they send those letters out under the candidate's name? Go ahead, go up a little bit. Go up. That art is Art Wittig. All those candidates sent in scanned signatures into that direct mail operation. They were imprinted electronically into the machines and scanned onto the letters. That's how come they got so darn many letters out so quick. They had the system set up. Go to the next one, please. Now, the reason why this came out with the Whittick campaign was because that decision was one of 9, right? There were 9 candidates in the 2010 primary elections. We missed 5, by the way. There were actually 14 that they were assisting. We didn't find the other 5 until we got the full document archive from the candidates. So we missed 5 Republican primary election candidates in 10, but we got 9 of them. One of them was Mr. Whittick, because the Colorado documents were only a partial archive. They weren't the full archive. There was more publicity about Mr. Whittick's, about the decision on Mr. Whittick than all the others combined. Go to the next one too, please. All right, so with all of that interest, and then Mr. Whittick responding so vigorously, go to the next one, please. Intensive litigation broke out. I've already described to you the discovery that Mr. Gerussi primarily engaged in, including travel to Virginia, Denver, Seattle, Fargo, Sioux Falls, I mean, less attractive places, and then all over the state of Montana. But now go down, please. And I don't know how familiar you are with, so depositions were taken, $10,000 worth. You can only recover certain types of mileage and travel if you can keep going down. But here's the part I didn't, it's $5,000 in that stuff. This is the expenditures. This is what we billed for winning the trial. This was what was at stake. Had we lost the trial on behalf of the state of Montana, there would have been a bigger bill against the state. But because we won, we were able to bill the other side for the costs of litigation. Now, here's the motion. Starting on 35, scroll down. You get $10 for every motion you win. Keep going. Look at that, $300 in motions. That's 30 motions. There were 30 motions that were filed that our attorneys defeated, or that we filed and that we prevailed on. That is intense litigation. That is a lot of litigation going into that particular instance. Now, how did Mr. Whittick defend? And how does that relate to what we're talking about in terms of individualism in election meets community standards? Let's go to the first one. Now, you might think logically, go ahead, keep going, that what you're going to be dealing with is a First Amendment speech. And originally, that's what it was. This is in the Wall Street Journal publication. That they, originally the defense appeared to be First Amendment, and there actually were First Amendment defenses in the responsive documents that Mr. Whittick's attorneys, and he was well represented. He was represented by Quentin Rhodes here from Missoula, and he was represented by a huge law firm out of Kansas City, Missouri. And then he was represented by his own law office, so don't feel like he was inadequately represented. He was adequately represented. They had a number of First Amendment defenses. Not a one of them was briefed. There were no narrow First Amendment defenses, although they're trying to raise them now on appeal. They were not raised, not preserved in the pretrial order, and not part of the litigation. Instead, go down to the next one. Here's what was litigated. A argument comparable to Mr. Boniak's, but of a different tone, that it was really a trial of punishment. And go to the next one too. There it is, vigilante justice. Something without basis that you were trying to enforce on somebody else. In other words, the community standard that we were applying wasn't applicable to the case, shouldn't be there, that he's being unfairly singled out. Now go down one more. This is the jury verdict. So 5 days of trial. I gave you a brief summary of the evidence. In that 5 days of trial, Sarah Arnold testified, Andrew O'Neill testified, C.B. Pearson testified, I testified. And of the 60,000 pages of documents, we winnowed it down to 300. And those 300 gave windows into the things that I told you about. How did the jury react? A trial, first of all, it's fair to talk about trials in this way because they're a due process mechanism that has been in our country for 200 years and in Britain far before that. In the course of a trial, both sides, following the rules, are allowed to present witnesses, cross-examine the witnesses as presented, introduce your own evidence, and as that's going on, a jury appears, in this case 12 people, sits on the side, listens to it all, and decides in the end. And what did they decide? Well, at the end of 5 days, on a Friday afternoon, April 1st, they came back with, on the first decision, did defendant, Mr. Wittig, fail to maintain and preserve records of his campaign and contributions. And that was based on the documents we were able to produce and the documents he didn't produce. The jury said, yes, he did. Question number 2, did he accept or receive corporate contributions? Yes, he did. Now, those are community standards. Do you remember the policies that I gave to you? Clearly, within those policies, regardless of whatever constitutional scissors you might apply to it and narrowing to a particular situation, you still cannot take a contribution from a corporation in Montana. That is illegal. It is prohibited by our law. And any contribution that you get, you have to report and disclose. What contributions did he receive? What he got was paid personal services from a whole host of corporate staff people. Everything from his website design, which Andrew O'Neill designed, to the incredible identification of issue-oriented voters in his legislative district, which Andrew O'Neill and Sarah Arnold designed, to the letters, which were written by the national staff person in Washington, D.C. That value wasn't reported or disclosed. That was value provided to him by in-kind paid staff people, by paid staff people of corporations as an in-kind contribution to his campaign, not reported or disclosed, and it was illegal to accept it anyway. It was a corporate employee. It was a corporate expenditure. Go to the next question. And did he fail to report contributions, including coordinated in-kind contributions? Yes, he did. How much? That's what the jury valued, the amount of the in-kind services that he had, $19,599 in a Republican primary election in a Senate district in Bozeman, Montana. And the opponent who ran against him, Mr. Moran, testified, as did John Esp, that it was that sort of action that discouraged their belief in and their willingness to participate in the future in elections because of this sort of infusion. So now, what does that tell you, and what is the observation that I want to give you? And I think this is what I would leave you all with, is this. So I think beyond question, community standards, community election standards, determined by the people of Montana, reposited in the commissioner to advance, were violated in Mr. Wittig's case and Mr. Boniak's case. In Mr. Boniak's case, the determination as to violation was made by a judge. In Mr. Wittig's case, it was made by a jury. And it was not a weak jury verdict. Those of us in the courtroom that day, that was a jury that was firm in what it decided and what it believed in. They knew what their decision was. They believed it was the right decision. They said it with forcefulness. It was the delivery of a community standard. Now, how does that relate to individualism? Well, remember what I said about individualism. Individualism in elections is not reconcilable with community standards in elections. at least not the way I'm defining it, because in individualism, you don't accept the community standard. And therefore, you don't accept the community standard whether it's delivered by the commissioner, by a judge, or by a jury. And Mr. Wittig didn't. He ran for office in 2014 after the commissioner wrote his original decision, and he ran for office in 2016 after the jury delivered its decision. Now, he didn't get nominated by the voters in Gallatin County, but he still ran for office. It was an act of individualism. Now, I think here's what you need to walk away with from that. It is something that you need to understand beyond the venue of principled debate. This is not an issue that Anthony Johnstone is going to be able to resolve when he finally is able to get this Citizens United back in front of the Supreme Court. And that issue is resolved in a way that is more compatible to American election culture. That's not what we're talking about here. And we're not talking about the sort of philosophical debate, which is totally proper, about whether or not we should have anonymity in election speech. I don't think that would go anywhere in Montana. 73% of the people voted in favor of a policy which is directly against it. So I don't think that would be what a majority of Montanans would be in favor of, but it's okay to have that debate. This is something entirely different. It has to do with individualism in elections working regardless of community standard and in the face of community standards. Just as Mr. Wittig ran again in an election in 2008, 2010, 2012, National Right to Work came back with that same field staff and worked in the same way on behalf of candidates for public office in Montana. And they even tried it in 2014 after the commissioner's office began to move on these particular complaints. That individualism, because it exists separately from the community election standards, is always going to be there. And you have to understand and expect that it is going to be there. The only way you are going to be able to deal with it is to hit it directly when it occurs. You have to respond as a community, either through the commissioner's office or in some other way as a community, because it is not going to go away and it is going to get bigger if you don't. And that is the insight, as simple as it is, that I will give you after 3.5 years at the commissioner's office and after working on 190 cases, including a dozen cases that directly concerned the 2010 Republican primary election races involving 9 candidates, and now we have 3 involving the corporate entities that were involved in those candidates. What happens if we don't respond as a community? If we can put the next one up. This is what we get. This is the Guardian article on what happened when Wisconsin's community lost a very comparable battle in the gubernatorial race in Wisconsin. The documents were ordered, sealed, and destroyed by the Wisconsin Supreme Court, but some particular person involved in that campaign kept the documents on a disk. They were leaked to the Guardian. The Guardian does the article on it. This could be the same story that we went through in Montana. The same sort of evidentiary base, the same sort of working hand in hand of a candidate with corporations. But the ability of the community to respond with the community election standard wasn't applied in Wisconsin, and it's not going to be applied. So the politics of Wisconsin is continuing in that way. And I know we're not a lot of Montanans in this room today, but a number of you are young. I think this is a battle that you're going to be continuing for a long, long time. And you need to never back away from it, whether it's now or 10 years from now or 20 years from now. And that is what I have to say about individualism in elections as it meets community in elections. Thank you. If you think about a commission and you've got somebody reporting to a commission, you're probably going to have one attorney just reporting one decision and then working it. It's going to take a long time. So Montana's system, in its agility, it can be weak because we only have one commissioner, we don't have a commission, there's no check and balances. We get a situation where, as Anthony said, we've got a long period of time where the Commissioner of Political Practices does nothing. On the other hand, if the will is there and we can survive confirmation, a commissioner can do something.
If an individual is found to not have abided by the community standard, how are they allowed to run for political office again?
And that was the issue we posed to Judge Dayton at the end of the Wittig trial. And what Judge Dayton said is the statute says must remove from office or candidacy. But he said, and I think he's correct, that I have to read that in the narrowest way in order to preserve the constitutionality of that statute. And I'm going to read that to say it applies only to the office in which the campaign practice violation occurred, because Mr. Wittig ran for the Senate and was currently serving in the House. Those are two separate campaigns. The campaign practice violation was over for the Senate. What it says is that the little speech I gave you about vigilance and about necessity of enforcing the community standard, there's also justice in that, and justice is only going to be served if you move swiftly. When I got there in May of 2013, I had until June of 2014, well actually May of 2014, to even decide the original sufficiency decision and get the case into court. I had to be in court within 4 years. Well, I got into court in the 4 years, but not soon enough to trigger that removal portion.
So the cloak and dagger story around Western Tradition Partnership makes for fascinating listening and reading, but isn't the problem now really national groups that hide in plain sight? So National Right to Work can simply set up, in its view, comply with the law, set up a Montana affiliated PAC, and then write $1 million check to it and not disclose the source of that fund at the national level because it doesn't claim that it's a primary purpose committee. Isn't that how politics is played now, with the national groups writing big checks to affiliates and then they say they comply and we still have no idea until they file their taxes the next year where the money comes from?
So what Anthony is correctly pointing out is that the Disclose Act we passed in the 2015 legislature requires within 60 days of the start of voting a complete reporting and disclosure of all expenses. If you spend money on an ad, a flyer, you have to tell the people of Montana how much you spent and when you spent it. But if you're a particular type of political committee, a federally filing committee, which is the example you gave, or a committee that engages in activity other than political election activity, that's called an incidental committee, you do not have to report the source of the funds unless those funds were solicited specifically for the purpose in which you're using it, that is election purposes. And that is a loophole. And we need some very good minds. Sandy Welch is here. She worked on that Disclose Act, spent a huge amount of time on it. If anybody could have come up with a way that we were reasonably confident we had a constitutionally permissible solution to that, it would have been in there. We couldn't do it. I mean, the group of people that were working on it, the law was in such flux with different circuits saying different things. I think it's for you guys, the litigators on constitutional issues, to give us a better pathway that we can do what you're suggesting we should do. But right now, we don't have that guidance. And so that's going to be a loophole for a while until we can close that loophole. Question?
Are you leaving office because you want to, or is there a chance you would be reappointed, or?
Can't be reappointed. You can only be reappointed for one term. And when I was appointed, I was specifically appointed with my term ending December 31st, 2016. Now, you probably know that there's been a revisionist review of that that says that was a mistake, that, you know, why did we go through all this battle to confirm you if you didn't get what the statute says? Upon confirmation, you get 6 years. So that is an issue that who's ever elected governor will probably have to take up, but I'm expecting I'm out 12/31/16, because it would take a bit of political will on the part of an elected official, and that's not exactly a common commodity. Question?
So if you end December 31st,
Right.
then does the governor appoint someone for January 1st? And then by the end of the legislative session, then they'll confirm or not confirm that person?
That's the way it works.
Because I guess I was thinking too that they're talking about not being quite as agile as far as the way it's set up now, but have some kind of a different way of appointing, et cetera.
I can't imagine, if the current governor is reelected, that would ever get by him. For whatever I might have said about his, I think he litigated, along with Mr. Johnston, he litigated Citizens United. I think he wants as agile and forceful a commissioner's office as is possible. And I don't think he would substitute. The problem with the commissions is you substitute political gridlock if you've got people from each party, and slowness.
Oh, okay. So, so there's two different things. One, I guess I wasn't very clear in my own head. So one thing would be how the person's appointed versus whether there's an actual commission, you know, with more people than just the commissioner. So if he appoints on January 1st and the legislature decides that it's going to be like a Republican, a Democrat, and some kind of mix, anyhow, a different way of appointing, it would already have been done, so that wouldn't actually happen.
Yes, that's correct. Yeah, the next commissioner will be appointed under the current statutory scheme. Question?
So I really have two questions. One of them is on the 1L, and we just learned about Rule 11. And in the Wittig trial, those 30 motions that you won, every single one of them, just interested in the concept of is that just how litigation of this level is going to work out? Or would there possibly be grounds to move for sanctions on that many motions? And the second one is, I understand why 3 of the justices in the First Judicial District Court had to recuse themselves, but I didn't know what Judge Seeley's reason was for in the Wittig trial. I was wondering if you could clarify that for me.
She wasn't recused. The other side paid $100 and disqualified.
Oh, okay.
And given a trial like this, the judge, and I think most judges would do this, gave a great deal of latitude to the attorneys representing Mr. Wittig. I can't imagine a circumstance where he would have applied a Rule 11 to him. He let him file any motion he wanted and let him brief it and then wrote a decision on it. Because you saw the defense, which was vigilante justice, so I think the attitude of the trial judge was to provide due process to the greatest degree you possibly could. Correctly so, I think. I don't have any disagreement with that. Oh, one more point.
First of all, I want to thank you for being here I took the occasion of this lecture as a prompting to Megan to provide my class in American government extra credit as they came to hear what you had to say, and many of them are here.
Oh, good. Thank you.
Reflect on your sense of what the fragility of the community standards is following this case and any future cases. Do you think it will withstand further rejection by candidates that may adopt the individualism that you spoke of? And will it withstand that?
I think that you have to see the willingness to apply election individualism as the beast in the cave. It's not going to come out if it believes there's going to be a light shown on it and that there's going to be a discussion of what it's doing, but it is always going to be there. Now, how firm do I think the community standards are? I think that whether you're a conservative Montanan, a liberal Montanan, a middle-of-the-road Montanan, I think the bulk of Montanans want elections fair. I think regardless of political party, the bulk of Montanans want elections fair. And I happen to know something about those 12 members of the jury because when you're involved heavily in a case, you do learn a little bit about them. There were some very conservative people individually on that jury who were part of it was a 10-2 vote, and they were part of the 10. So I have a lot of confidence in Montanans. I think Montanans want fair elections. We can't afford a lot of governance. We're always going to be thin on whatever we do on this. We can't. We're a huge state with a small population and not that much money. And so as few as we are in this room, this is a lot of people. And vigilance can come from the few as well as the many. And for those young people, you can take a career in some corporate PR agency, and I did that when I was in law school. I worked on the 12th floor of the First National Bank building in downtown St. Paul for Briggs & Morgan. And I passed out a few times on the conference room table, saliva dribbling out of your mouth at 10 o'clock at night because you were working there. You don't really want to do that. I mean, you're only young once, and you only have one chance and you're only old once. I mean, I got two chances. I got a chance once when I was young, and I got a chance once after I was 31 years old. After I was 31 years in private practice to go ahead and do this stuff. So you get two cracks at it, really. You get at the start of your career and at the end of your career. But, our office has 7 staff people. 2 of them are recent political science graduates. They do this day in and day out with candidates in the state of Montana. Find yourself some public service. As long as you can hold out with repayment of your student loans, get some public service, serve for a while, as long as you can, then do what you have to earn money. But don't ever lose sight of public service. I mean, it hasn't been in favor much the past few years, but I think it's time to get back. And boy, does your community ever need you. I mean, things like this office, it needs dedicated people doing this job, not as a state employee, but as a state employee doing public service. Okay, any more questions?
I would just like to add to that, even as community members, I think we have an obligation. I come from a smaller rural community, conservative community in Montana, and we were having nasty school board elections where they were not disclosing who was paying for their their materials, and it took a couple of us, shining the light on it, and the elections in that community are being run a lot better. But it needed to happen because it was out of hand.
Right.
It's really heartening. What's going on with the Disclose Act? I can't remember what challenges there are now, and it's still standing, or it's half standing, or?
The entire act is under litigation in one form or another by the Bopp law firm out of Indiana. Judge Christensen has part of it. Well, he's got all of it, and he's got it in two separate cases. He's issued one preliminary decision, which was very favorable to the Disclose Act. And I think, as cautious as we were with what we put in there, as far-reaching as people say it was actually a pretty careful piece of work. So I'm pretty confident it'll come out okay. Question?
It seems to me that we're sort of lucky in Montana that we have the commissioner's office, and we also have the ability to do these citizen initiatives, right?
Mm-hmm.
If not in every state,
Yep.
can you even have an I-166 or an I-182 or whatever? And that kind of direct democracy is really a special sort of thing, I think.
Yeah, I agree, and it's the responsibility of all of us to recognize that and recognize that there's a beast in the cave, too. And we've got to be aware of that. I mean, we can't think Anthony Johnston is going to save us with brilliant First Amendment litigation. It isn't going to happen. He won't have anything to save if we don't deal with this stuff when it happens. Okay, thank you all.